Morning, Your Honor.
We're here on the case of Carr versus Boys and Girls Club. The other panel members joining me today are Judge Richard Orfinger and Judge Brian Lambert. Can you each see the clock on on your screens?
Yes.
Yes.
Okay. How much time does the appellant's counsel wish to reserve for rebuttal?
3 minutes, please.
Okay, I'll try to help you. Keep track of your own time, but I'll try to help you in that regard. Also, I want to advise you that these arguments are being streamed live so the public can observe them.
Sure.
Okay, the appellant's counsel may proceed.
Thank you, Your Honor. I am David Charlotte, and I represent Shanice Carr, who is the personal representative of the estate of Ariana Carr. She's the plaintiff appellant, and we are here seeking a new trial on damages and or alternatively a reversal of the allocation of fault as to the trial that occurred below. As the court is aware, the jury verdict assessed 80% negligence against the driver of the vehicle that struck Ariana, and 10% against the Boys and Girls Club, 10% against Ms. Carr. So today my arguments are twofold. First argument is that this was a flawed trial, rife with cumulative error that denied the plaintiff a fair trial as to damages and allocation of fault. The second argument is that the jury verdict is against the manifest weight of the evidence on the issues of allocation of fault. And I'd like to take the court through the sub-issues dealing with the first argument now. The major issue in the case was the fact that there was a DCF investigation, and the Ms. Carr's other children at the time were not living with her at the time of trial. And we had brought that issue up on an in limine basis, secured an order in limine that there was to be no mention of the DCF investigation. The issue of where the kids were living was brought up by the defendant, and the trial court initially ruled that the danger of prejudice outweighed any probative value of getting into that issue of residency. The court said, however, that if the plaintiff opened the door, she would revisit that ruling. Now, this was a wrongful death trial, and obviously the key issue was the extent to which Ms. Carr had damages related to the loss of her daughter. And the statute talks about the damages that the survivors suffer relate to mental pain and suffering from the date of the injury. So quite naturally, Ms. Carr testified about how losing her daughter caused her mental pain and suffering. And that testimony, the court found, unfortunately, would open the door to the issue of the other children's residency. But in reality, that's the court testimony that one would expect when a plaintiff is testifying about the loss of a child. There are many issues in life that cause distress, and the fact that you have other issues that give you distress really are not relevant to the distress you feel for losing a child. So it's really apples and oranges. We made that argument to the court, but the court allowed the defendant to go into that testimony and point out the children were not living with Ms. Carr, and that caused her some distress. But it gets worse, because despite the fact that the in limine order stood and the representative of the Boys and Girls Club, Mr. Bastias, was aware of the in limine order, and that the court found that she wasn't going to try a dependency case, the question was put to Mr. Bastias about whether he had previously contacted Ms. Carr when the children had missed the bus and were going to go home late. And he interjected that he previously called the DCF on Ms. Carr. And that was something that we warned the court about, and nevertheless, Mr. Bastias testified to that. We immediately moved for a mistrial at that point, which the court denied and gave a curative instruction. But at that point, you heard that Ms. Carr had been investigated by the DCF, that the Boys and Girls Club had contacted the DCF a number of times. So the trial proceeded, and the trial proceeded, and on cross-examination, the cross-exam of Ms. Carr sought to paint Ms. Carr as a bad mom. And over-objection brought out a number of things that had nothing really to do with anything but Ms. Carr's character. The defense talked about how she did not have a Florida driver's license, asked her about her driver's license in North Carolina, asked her about her schooling and whether she received a diploma, asked her about the transportation decisions she made prior to the incident, the date in question. At the time of the incident, Ms. Carr was not called. That was undisputed. At the time of the incident, she was not aware the children had missed the bus. She was not present, and there was no basis for the jury to assess any comparative fault on her part. She had testified, and it was not in dispute, that she wasn't going to send the children to the Boys and Girls Club, but for the fact that the Boys and Girls Club had agreed to watch the kids go and get on the bus. And
well, when you say it wasn't in dispute, didn't Mr. Bastias explicitly dispute that?
what Mr. Bastias said was that he did in fact watch the children on occasion. He didn't do it every time. And he said that it wasn't his job to get the kids home safely.
But there was a clear conflict in the evidence. She said there was an agreement between herself and Bastias to see that the girls got safely to the bus, I guess. And he said there was no such agreement. I mean, wasn't that a clear conflict in the evidence?
He said that there was no agreement, but essentially the elements of the agreement he admitted to doing. So he said, I didn't have any kind of agreement with her, but I did watch the kids. And the question was put to Ms. Carr, well, were you looking for the Boys and Girls Club folks to walk the kids? And she said, clearly, no, not at all. I just wanted them to make sure they got on the bus. And if they didn't get on the bus, to call me. And in the two instances before this occurred, where the kids missed the bus, that's in fact what happened. They called her. In one of those incidents, they tried to get her, couldn't reach her, and they contacted the sheriff, and the kids were taken home by the sheriff. In this instance, they didn't call her at all. And this was the one time when the children actually left and it was dark outside. So on the other two instances, it was always light outside. So whether there was an agreement or not really was not material, because the children, based on the club's own rules, based on the prior course of conduct, and just based on common sense and reasonableness, should not have been released from the club without a call or other arrangements being made for them to get home at that point. To continue, though, the matter was made infinitely worse and more prejudicial at closing, because at closing, defense counsel says that you don't know why the children are not living with Ms. Carr. He says, and Your Honor also told you you can draw inferences from the evidence, right? You all know what an inference is. You've heard that the three girls haven't lived with the plaintiff. And at that point, I objected. And the court overruled the objection, and he continued. The three girls, and then he says, two girls and one boy haven't lived with her since the spring of 2016. You don't know why but you as jurors are absolutely free to infer why. So he is asking the jury to go outside of the evidence into an area that the court had already ruled pre-trial was more prejudicial than probative. During the trial, although she allowed the issue of where the children were living into evidence, certainly the inference as to why they were living there was excluded. And nevertheless, he said to the jury, despite the fact that the judge didn't tell you or didn't allow me to tell you why the children weren't with mom, you can speculate outside of the evidence as to why they were there. Now, quite frankly, the only
isn't that the time you needed to object?
Well, I had objected. I actually said,
but what you objected to was not objectionable. The comment wasn't objectionable at the time you made the objection, because that was in fact the evidence that the kids had not lived there.
But I told the judge where he was going with that objection.
You have to wait to see where he goes, don't you?
I said he's telling the jury why, and she said objection overruled. And
which was that's a correct ruling at the time.
Well, she admonished me that I couldn't object and shouldn't have objected. And I felt like I preserved the error by saying, Judge, he's going there. Now, I didn't want a mistrial at that point. I wanted to stop him from going there because I felt the next thing would be to move for a mistrial. And she said, no, I'm gonna let him.
Well, but I mean, because you haven't objected to what you're considering is the problematic statement made by opposing counsel in closing, now we go to a fundamental error. And how does this meet the four-prong test under Murphy, Supreme Court's case of Murphy, especially the last prong?
Well, I don't respectfully agree that we're at the point of fundamental error. I made the objection at a point where he was getting into it.
Well, if we assume that we think it's a fundamental error analysis, then go ahead and answer the question, please.
Well, it's a harmful argument outside, as the jury to speculate as to matters outside of the record, painting the plaintiff as someone who is being investigated for not being a proper mother and losing her children to dependency. It's incurable because once the cat is out of the bag, which we felt the mistrial should have been granted when DCF, contrary to the prior in limine order, was brought into the case to begin with, it so damages the fairness of the trial that the public's interest in our system of justice requires a new trial. I mean, here, basically, the jury
is that what prong 4 is, though, under Murphy? Isn't that more of a, you're making a comment that talks about racial or religious stereotype things that becomes where the Supreme Court has basically said that is the prong 4 type of analysis, which we don't appear to have here?
Well, I think on a per se basis, yes, but essentially, when you're violating the rules of professional conduct, when you're asking the jury to go outside the record and inviting them to do so, something that I tried to stop by objection, I think that also damages the public's interest in our system of justice. And we're talking about cumulative errors here as well. So it's not just...
Ask you to shift gears here for a minute and help me understand your argument that Ariana's death was not caused by the other driver, Barry. You said on page 16 of your brief that the club didn't prove that her death was caused by anything that Barry did or failed to do that constituted negligence.
Sure.
And wasn't he the direct cause of the accident? Didn't you sue him?
We initially sued him, did not get service, and dropped him. So the affirmative defense of Fabre was brought in by the defendant, and it was defendant's burden to prove negligence on the part of Barry.
Well, what about the testimony of not only the older sister, but more importantly, the driver who was in the car next to to Mr. Berry. I mean, isn't that enough to suggest that there's substantial fault and negligence on his part?
No, absolutely not, and I'll explain why. First, the officer explained that the physical evidence established conclusively the point of impact was either in or near the north side crosswalk in the northbound lane of Pine Hills Road closest to the median. The Ms. Harrison, the other driver that observed how the accident happened, unequivocally testified that Berry crossed through the intersection with the yellow light. So there was no question but that she said the light was turning yellow, Berry crossed, it was still yellow, I stopped. Now, Alexis, the
but taking the evidence from the investigating officer, if you run over a pedestrian in the crosswalk, doesn't that suggest some negligence, at least in the average case?
No. The question is who had the right of way. In this case, because the light was still yellow, the pedestrian violated the driver's right of way. So there's
Wasn't the other driver's testimony that the light started to turn yellow, so she slowed down, and the other driver slowed down for a second and then sped up? And isn't that a more correct statement of her testimony?
that is correct. But the fact that he
So
slowed
was she
down,
sure the light was yellow, or did she say it was yellow and she slowed down and she wasn't sure whether to turn red or not at the time of impact?
she testified the light was yellow at the time of impact. She did not say he ran the red light. So that point was very clear. The daughter's testimony was all over the place because the daughter essentially testified that they crossed two streets, which couldn't have happened because the accident happened on Pine Hills Road. And in order to get to the bus stop, they had to either cross Pine Hills Road first and then cross the other street, or they had to cross the other street first and then cross Pine Hill Road, which would put them on the south side of the intersection, not on the north side where the accident happened. And she testified that before she crossed the street, she had to try to change the light because she pushed the button. So her testimony really makes no sense when you look at it. It doesn't comport with the undisputed facts about the physical location of where the accident happened. It doesn't comport with the way she testified they usually cross that street. And it otherwise doesn't support in any way, shape, or form the burden that the defendant had to prove negligence on the part of the driver. And so on that basis, there really is no evidence that would support the Fabre allocation of fault of 80% to the driver. Additionally, it was our position that it's reasonable for Boys and Girls Club to assume that if you let the kids out on a dark and rainy night at 8 o'clock when they're supposed to be let out at 6:30, they never should have been let out to begin with. That one of the things that you are seeking to prevent is just the type of incident that occurred in this case. And that's intervening fault, the instruction for which we sought, and the trial court, although she gave it during the preliminary instructions, refused to give it on the final instructions, which was a key part of our case because we contended throughout that Ariana should not have been discharged when she was discharged from the facility by
Mr. Charlotte,
Mr.
you're down to about 1 minute and 10 seconds. So if you want to save remaining time for rebuttal, you might want to do that.
That's fine.
Okay, thank you. Mr. Altenburn?
It please the court. My name is Chris Altenburn. I'm a member of Banker Lopez Gassler, and I'm here today representing Boys and Girls Clubs of Central Florida.
Mr. Altenburn, let me jump into the two issues that concern me, both of which are real. One is the statement that counsel emphasized. You've heard testimony that Mrs. Carr, the three girls, haven't lived with her since spring of 16. You don't know why, but you're absolutely free to infer why. The second thing that concerns me is the evidence that was introduced, and I'm not even so much concerned about the introduction, but the fact that the drum got beat awfully hard, and that is about her lack of a driver's license, her brushes with the law, whether or not she had a stolen plate on her car. So those things concern me about the overall picture that was being painted here, which was she's a bad mom, and she was a factor in this. So tell me, let's talk about the first statement, which is the inferences. You don't know why the kids aren't living with her, but you're free to infer why.
Again, that's in closing argument, and Judge Lambert is correct in terms of how this came about. If you look at the transcript on this, is that the judge, you know what an inference is. You've heard that the three girls haven't lived with plaintiff 4, and at that point in time, Mr. Charlotte does object, but his objection is it's beyond the scope. Well, it's not beyond the scope, because that's actually the question that the judge herself fashioned to be the narrow question about the children not living with mother after sometime in 2016. So the judge properly overrules that objection. It proceeds, and he does go on and say that since the girls, you've heard testimony that Ms. Carr, the three girls, 2 girls and 1 boy, haven't lived with her since the spring of 2016. You don't know why, but you are free as jurors to absolutely free to infer why. Now, if you put this into the context of the overall closing argument, there's no objection at that point in time. And Mr. Charlotte's initial brief this is fundamental error. Is your
argument though that that's a proper argument to be made, or that merely isn't preserved? It's an improper argument, but the error isn't preserved.
I think that statement's pretty oblique, is what I said in the brief, and I'm not arguing hard that maybe it should not have been said. But the problem here is that there was no objection at that point in time. And if you go through the Murphy standards, or the standards that this court used in First Health versus Cataldo, it just doesn't fit them. The simplest part of this is to explain that, the last 2 prongs are, could you correct this? Well, the objection is going to be, I assume, that this is not relevant. And the judge could very easily have told the jury that where the children lived on that date wasn't going to be relevant to what they were considering in the jury room. And as a practical matter, the judge told them the standard instruction on inferences, which is you're only supposed to do this if there's evidence to support the inference. And I'm not sure that the one answer by mom to that question would allow for an inference to be done from that. So whether this impacted anything given the jury's verdict is a little unclear to me. And lastly, you only correct a fundamental error in a closing argument if the argument so damaged the fairness of the trial that the public's interest in our system of justice requires a new trial. This is basically, we correct fundamental error to protect the legitimacy of the court process. And this particular issue certainly does not arise to that. I'd point out that there wasn't a single objection about anything else in closing argument. This is one line in a several-day trial at the close of the case. So I do believe it's properly analyzed under fundamental error, and under that standard, I don't think that this is reversible in this case.
Talk to me a little bit about the testimony that was introduced about the driver's license issues, the allegation about stolen tags, and brushes with the law. and how that's relevant to prove anything other than she's a bad person, bad mom.
You know, this was raised in issue 4, which is sort of a collection of things. And I would start off with the fact that there was a series of things that there was impeachment on. But this woman was trying to justify that she wasn't driving to pick up her children because she didn't have a car. And the truth was that she didn't have a valid driver's license. And the process of going through to finally get her to admit, I didn't have a valid driver's license, admittedly took a long time, because she didn't just admit, okay, I don't have a Florida driver's license, but the license I had in North Carolina was suspended. She didn't go through that process. So there was a lot of cross-examination on this. And you know, that this is an experienced trial judge who was trying to rein in this to some degree. And I don't think that there's an abuse of discretion given the objections made and how it was done as to any of this cross-examination. Because, you know, as I think you pointed out earlier, that the issue here was whether mom was telling the truth about a lot of things. And she had, if you look at page 640 of the record, her understanding is, 686 of the record, that her agreement with the boys club was, the agreement was, quote unquote, we will supervise your children and make sure they get on the bus safely, end quotes. There was no specifics to that. So she was taking this position that because the safe passage policy would have relieved the Boys and Girls Club of liability, that she had this extra agreement with them to do that. And that she was, it's not that she's a good mom, but that she was doing all of these things to protect them in this particular context. And one of those things was that she couldn't drive them because she didn't have a driver's license. So again, in the overall context of this, I don't believe that this is just making her a bad mother. It's trying to show that the image that she was portraying of herself in order to establish that she didn't reach the reasonable standard of care that a parent owes to their child about how they safely get either across the street or home from the Boys and Girls Club. I think that was not an abuse of discretion by the trial judge to allow that testimony in. And certainly once she portrayed herself as a college graduate that had these jobs based on the college degree, the testimony to show that Kaplan University only had records that she'd signed up and never gotten a single credit was something that was well within this. The plaintiff's initial testimony concerning this woman from when they first put her on the stand goes through this college degree and that she was coming here to be a general manager of Verizon fiber optics, and none of that is true. So the cross-examination of it was pretty vigorous. The trial judge was not an abuse of discretion on that.
Mr. Altenburn, let me ask you, what is your understanding of the testimony of the other driver, Ms. Harris, as to what happened at the time of the accident?
Ms. Harris and Trooper Gensler are probably the most credible part of the version of the automobile accident, although the older sister does say that she punched the button to get a light and she waited until the light was red before the children got across. But my understanding is that the two of them have been going on this road more or less side by side, switching sides of the street from a place called Cortez Boulevard, which is maybe half a mile or so south of here. And that at the time of the light, she's coming up, she sees the kids at the crosswalk. She clearly sees them on the north side, by the way, and that she begins to come to a stop. She says she's focused on the children and that she believes the light was yellow turning red. And so exactly what it was the moment of the impact, I'm not so sure. But she says that she sees the other driver. She's assuming his lights, that he braked because she sees the brake lights, which means he's in front of her. And then he speeds up across this intersection and runs into the children. Now Trooper Gensler has the point of impact on the north side of that crosswalk at a spot where it's only a couple steps to, they're describing as a median, but it's really a wide turn lane. And so this man drove through an intersection that has children crossing in front of him, that does not put on the brakes, and manages to run into this girl with his left driver's side fender just before she gets to the median. Frankly, whether he had a green light under those circumstances, it would probably have been negligence on his part. But certainly running through a yellow or running through a red, placing 80% on him for this makes entire sense. I'd comment, by the way, that in the reply brief, there's this claim, well, that the older sister has a version that they went on the south crosswalk. You know, the children have been crossing here daily for a couple months, and it's a catty corner situation. So odds are some days she went south on Pine Boulevard and then crossed it, and sometimes she went the other direction. So she may very well have been confused. But if the jury accepted her testimony, instead of the throw of the child from the point of impact being 36 feet, it would have been closer to 75 to 80 feet because of the width of the street on that. And that would have meant that the driver was driving substantially faster than 35 miles an hour on that street. So one way or the other, there's substantial evidence of his fault on that. Now, on the question of the one question that the trial judge fashioned on the children not living with mother at this time, I think that it's important to actually see the testimony on that, because this is not a case where the mom just says, you know, I really miss my daughter. She died and I grieve her. She went on to explain that not what she did for this child or how she missed this child, but two things. I don't cook for Thanksgiving or Christmas the way I used to anymore. I don't. It's just certain things I don't feel right without her. And then she says, I used to put on music and get a broom and brush and play with the kids and like link sync with Goofy with the kids. And I don't do that anymore. Now, Plaintiff's counsel had been warned that if they opened the door, that some of evidence could come in. And this trial judge flat out explained that she wasn't going to make this a dependency trial. And that's a good thing for her to have done. But she allowed one question to point out that this time period when the woman is saying she doesn't play with the kids and she doesn't cook with the kids, they're not there. There was no explanation that they're not there because they were taken by DCF. And I don't see that that is an abuse of discretion in this case. If you look at the testimony and cross-examination by Mr. Bastias about how he called the police and called DCF, again, that's a situation where you need to take a look pretty carefully at the transcript. This begins on page 529 and it goes on. Because what happened was he's beginning to get into the DCF on cross-examination. The question, it's a leading question. Isn't it true that you got a hold of the mother on the times you called her? And he's saying, no, that's not true, and begins to explain it. That's how he gets into this. Well, when he begins to get into this, trial counsel doesn't object and try to stop it. Trial counsel interrupts the witness and starts talking to the witness. And then that's at the point in which the trial judge says that she's going to allow the witness to respond unless sustained. I think giving him a hint, if you want to make an objection, now is the time. But no objection is made, and the witness makes the reference to DCF. And this is, I don't know this judge, but she's clearly experienced. She goes right into this. She sustains the objection. She pulls the jury out, and she goes through, is there another motion you want to make? And lets him make a motion for mistrial, and explains that she doesn't think it's the focus of the trial, and that under the circumstances, she's not so sure that this witness even understood there was a motion in limine in play, and makes a ruling on that. Ask them, is there anything else you want? They agree on what I'd call a plain vanilla corrective instruction, and that was done. So again, in terms of a reversible error, this trial judge did this by the book. She didn't do anything that I think was reversible. On the jury instructions, he's only mentioned the one on intervening cause. This is not an intervening cause case. The negligence, the essential elements, the last element is damage, and the damage for the driver, for the mother, and for the Boys and Girls Club is the death of this child, that the damage is all occurring at the same time. We use intervening cause for things like a doctor's malpractice or a second impact products case where you have an injury from the driver followed by an injury from the car, and intervening cause is given to prevent the jury from being confused about that. But this is a classic concurrent cause case. He hasn't argued it much, but one of his points was that there wasn't evidence of the mother's comparative negligence, and that the judge should have granted a new trial on that for manifest weight. Obviously, your standard on this is abuse of discretion, and the trial court can only grant the new trial really if there really isn't significant evidence that supports the jury's verdict. So the question there was whether a jury could find that the mother in this case breached the duty of reasonable care that a parent owes to their child under like circumstances. And the plaintiff's counsel seems to believe that she has to have been there to be negligent, but the issue here is what do you do to protect your child from the risks of either the narrow risk of crossing this street where there's a traffic light or the broader risk of getting home? And it's undisputed that these children had been crossing this street normally at 6:30 in the evening for 2.5 months, and that no one from the Boys and Girls Club was going out all the way to hold their hands and get them across that street. She knew that, the children knew that, and she had done nothing to change that despite her insistence that she had this special arrangement with them. I'm not going to beat her up on the internet, but there were lots of things that she could have done to make that safer. And likewise, she's having this children travel an hour on a bus with 2 transfers to get home. She sent them there that day with the older sister not having a cell phone to call her, not having even money to get on that bus to go home. She had to borrow that money from Boys and Girls Club. You look at this whole picture, the notion that a jury couldn't find 10% on mother, that's clearly not a manifest weight issue. I would like to comment, since we're on the internet, and this will be archived, that I've read the transcript. Boys and Girls Club raised the comparative or a Fabre on the older sister, and she should know that there is absolutely no evidence in this record that she ever did anything wrong in this case. So,
Thank you.
unless there's any additional questions, that's all I have to say.
All right, rebuttal.
Yes, Judge, we knew from the very beginning Boys and Girls Club would try to make this case about the DCF. We did everything in our power to keep DCF out of this case, both on a pretrial in limine basis, early on in the trial, getting rulings in our favor, and yet we still could not keep the jury from hearing about DCF, from the suggestion to the jury that these children were not living with mom. And by the way, the children were not a judge dependent at that time. They had a temporary guardian. There's no evidence that would suggest that the kids were not with mom on Christmas and for certain holidays. And so it's utter and complete speculation. It's not probative to try to impeach mom on that basis. The objection I made was he is going outside of the evidence to comment, and that's where the trial judge cut me off. And prior to that, she admonished me as not being a person who is entitled to make an objection. I don't know what more I could have done. Thank you.
All right, thank you both. And I'll conclude the oral arguments for this morning, and court will be in recess.
Thank you.